Hello, students. This is Dr. Martin again. Just the next segment in the unit we have on the remainder of the legal system and the federal courts. We were talking about what the Supreme Court actually hears as the subject matter of its cases. Because of that subject matter, more recently in the last couple of decades, you'll see a lot of attention paid to who actually gets confirmed to the Supreme Court. Now, that kind of job is basically a job for life, either until the person dies, retires, or they get impeached for misconduct. Because of that, because of the fact that they could wind up shaping a generation's worth or more of federal interpretation of the law, more recently they have gotten a lot of scrutiny and a lot of controversy can attend their appointment. Always, this is going to pass through the Senate. The Senate is the body entrusted with approving justices, advise and consent. Now, because of that, the Judiciary Committee in the Senate is one of the more powerful committees in Congress, as we were alluding to a week or two ago. And therefore, who is on it has a chance to make some high visibility contributions to the nomination and confirmation process. For example, when you saw Senator Kamala Harris running for president this last year, one of the reasons she became well known was actually during the confirmation hearings of Justice Kavanaugh, where she was very kind of roughly grilling him on several subjects. So, the kinds of people that are actually going to get confirmed, it's become more and more professional, for lack of a better term, over the last several decades. A lot of times early on, you might find someone who's a veteran politician getting appointed to the Supreme Court. For example, Justice Hugo Black was a senator for many years. He had never sat on the bench before when he was actually placed on the Supreme Court, not at the state or federal level. However, more recently, it's going to be a almost second nature understanding that someone has to have had a pretty serious level of judicial experience before they get to the Supreme Court at the present time. And if not, then there are probably unique circumstances why that's the case. Now, to a certain extent, politics is going to have a lot to do with the process, obviously, but there are a lot of considerations that go into that. One, obviously, yes, are they of the same party? That's kind of a given. Do they, broadly speaking, agree with the president who nominates them? That's also kind of a given. But also, to a certain degree, what are the optics? That's become truer now than it might have been at one point. But in any case, the symbolic value of who gets appointed is going to be pretty profound. When Sandra Day O'Connor was appointed to the Supreme Court in the early 1980s by President Reagan, she was the first female justice, and so therefore she received a lot of attention from the press, a lot of letters written from the public, and she was also, during that time period, one of the most influential justices. On the court itself, you have a situation which you probably would never have thought was going to be the case once upon a time, which is to say that about half to a majority within the last several years of the justices were Catholic, and a few more were Jewish. Once upon a time, this would never have happened. This was a WASP, white Anglo Saxon Protestant institution, but slowly, in the interests of trying to symbolically show that the president wants to make the court look more representative, especially of his voters or her voters, then what gender the nominee is, what race they are, what age, all these start playing a more important role. Now, in terms of who gets to be a justice, obviously, as I say, a justice from a lower court, but you also see some who have been specialties in other areas of the law. For example, prosecutors. That used to be a fairly common qualification um, in terms of they've had plenty of court experience just on the other side of the bench. Also, you have someone, for example, like Justice Alega Kagan at present. She was a teacher, actually, a law professor for most of her career prior to joining the federal government under the Obama administration and then being nominated to the Supreme Court. Now, in terms of what that's going to see a change for, is a lot of the times the people who have not been judges before have gotten criticized for some of their opinions. The likes of Chief Justice Earl Warren come to mind. He was not a judge when he was appointed Chief Justice by President Eisenhower back in the 50s. He had been governor of California and also a top prosecutor, but he had never sat on the bench. And so there was a thought among especially conservative, both lawmakers and voters, that these people were making these decisions because they didn't really have the qualifications to actually be a judge. So therefore, the professionalism has certainly changed. Now, a lot of this is also therefore, as I mentioned, the Warren Court, the different kinds of courts. We call it the court because of the naming of it after the Chief Justice who oversaw it. Now, one of the things that I think is particularly interesting is that you're going to have courts go through a period where they are very activist and liberal in that sense, or increasingly turning the other way, activist and conservative. And that is nowhere truer than in the relationship between, say, the court led by Chief Justice Warren in the 1950s and 60s and the current Chief Justice John Roberts in the court he has led since 2005. They are, in many cases, very different in terms of the backgrounds of who actually sits on these courts. Much more professional judges in the case of Roberts, also including politicians in the case of Warren. But it's also the case that the direction of what they decided and how is very dramatically different. Just to talk you through Chief Justice Warren's court's contribution, many of the things that you take for granted or that you've learned practically by heart from previous classes or popular culture, I think you will recognize. And these you're going to want to have prominent in your notes if you get a question about the Warren Court versus, say, the Roberts Court. Under the Warren Court, cases like Miranda versus Arizona were heard, which is the right to remain silent, refuse the right to remain silent. Anything you can say will be used against you in the court of law. Griswold versus Connecticut, which is to say the right to privacy, was decided during this time period. You also have Gideon versus Wainwright, which is to say the right to have a lawyer, right to counsel when you are being tried. And also, most famously or infamously, Brown versus Board of Education, which struck down segregation in the educational system and therefore separate but equal as a doctrine with it. These were highly controversial and in certain parts of the country unpopular decisions when Justice Warren was actually in charge. Now, more recently, under Chief Justice Roberts, you're talking about much more conservative, relatively speaking, kind of course that they've taken. And I mean that in both a political and an a legal sense. In the sense of certain institutions or sectors of society have received a lot more attention and emphasis. Religious liberties are a big one. If you looked at what was called the Hobby Lobby case several years ago, this was a case when President Obama's Obamacare medical program was going to be requiring for certain kinds of employers to provide the option of ensuring things like contraception. You had a Christian employer in the case of the Hobby Lobby chain of stores who said that violated their beliefs and therefore their constitutional rights. You had a favorable reaction in their favor by the Roberts Court. You also had two particular ones that Democrats and particular are very upset with. One was a case called Yanis versus AFSCME. AFSCME is the American Federal, State, County, and Municipal Employees Association, the Association of Federal, State, County, and so on. In other words, one of the largest public employees unions in the country. Basically, under Yanis, they were basically stripped of one of their rights to collect dues from their members and other people in the workplace to fund their activities as a union, including the political kind. In this case, because you have a conservative employee who is part of one of those unions who didn't like his dues going towards the political activity of the union with the Democratic Party. And therefore, because that was struck down, the unions have been crippled to a considerable degree in their ability to spend money on political activities. Perhaps the most significant thing you've seen from the Roberts Court so far has been a decision, however, referred to as quote unquote Citizens United, named for a particular political organization that during the 2016 elections was trying to run a particular film negatively portraying Hillary Clinton as a candidate. But when they wanted to actually run it was conflicting with existing laws at the time that were passed for controlling campaign finances and advertisement during the time period leading up to an election. The ultimate result of that decision was to say that money equals free speech. The ability to spend money on political campaigns amounts for free speech, and that a group like a union or a corporation, functionally speaking, legally is a person that can therefore exercise their free speech by spending money politically. This was widely condemned by liberals and Democrats at the time because essentially this is the source of the kind of much derided notion of corporations are people. They would like to reverse that particular doctrine. And so when they've been scrutinizing President Trump's nominees for the Supreme Court, they're particularly looking for stances on that question. Can a corporation legally spend money to a greater degree, an unregulated degree, during a political campaign? Now, to a degree, these are features of two different ways of understanding the law. Broadly speaking, you can see originalism very much as a feature of the conservative justices' ideology, which is to say, original intent, original meaning of the Constitution by the people who wrote it at the time that they wrote it. And so, therefore, a lot of what they feel needs to happen is a return to whatever the source material of the Constitution was, or the source material of whatever that law that's being contested out of Congress is. When in doubt, look at the intentions of the original framers or the actual legislators. Because to go beyond that, they feel is beyond what a court is authorized to do. The opposite of that doesn't necessarily have a specific notion or name attached to it, but broadly speaking, a living constitution, which is to say, a belief that the Constitution was written over 200 years ago in times and places and operating under certain assumptions, including racial, religious, political, and so on, that don't apply anymore. And therefore, our interpretation of the Constitution should change with them. And judicial activism is what this particular viewpoint gets accused of by conservatives because it is thought to go beyond what the Constitution actually says. This is particularly, for example, in the case of something like abortion. Now, it's not just that you see an objection of something like abortion is wrong. That's going to be the case for a conservative audience. But that there is no right to an abortion in the Constitution. There was no actual way in which the framers or the voters have said that this is a right that should be protected. So, in both these cases, and in all the cases, the background of the judge matters, and the particular ways that they are going to establish and apply that law is going to matter even more.